Good morning, ladies and gentlemen. I'd like to welcome you to County Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning, we have two dockets. We have our motion to revoke probation docket, and we have an announcement docket. When I call your name, please come before the bench with your attorney. If your attorney is not here, we'll wait for your attorney to arrive. If you are not represented by an attorney, then when I call your name, please come before the bench by yourself. Let's see. Next, first case is 24-CCCR 2487, case of style of state of Texas versus Sean David Harper.
Well, I just agree. This would probably be amended.
Sean David Harper.
Okay, this is cause number 24-CCCR 2487. Case of style of state of Texas versus Sean David Harper. Mr. Harper, is that your full name? How are you doing, Mr. Harper? That's good. Mr. Harper, you're represented in your case by your attorney, Attorney Ryan Kimler. Mr. Kimler, how are you doing?
Well, thank you.
Mr. Tablets.
I'm going on with the monitors too. I can't get the Zoom, yeah.
And Mr. Let's see. The state is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm good, Judge. How are you?
I'm doing fine. And Mr. Let's see, I was on the wrong case. Mr. Kimler, what is your announcement in Mr. Harper's case?
I try, Your Honor, to set up, I think I filed a motion to press, but I'll probably come in and.
Okay, hold on a minute.
But it is a trial.
This is the second case on the announcement docket, Harper. Internal transfer, let me see. Proposed order, motion, request, motion. That's a DWI second.
Look like he did.
Oh.
Miss, could you give me some bond conditions?
That game too much.
Thank you.
Good. Well. Whatever you know. China. She's created these ones years ago.
Seven. Let's see.
This, I'm reminiscing, if you indulge me.
Continue to work, Brad.
You know, don't you three.
I've heard one too many things, but you always speak to those. I have no idea so much from her.
She's leaving, she's sweet, that's not.
Well, did they switch it over?
I don't think so.
She's leaving.
Okay, where's Andrew?
You might be still connected to that. Yeah.
Is Andrew coming down? He needs to connect the Zoom.
I'll think he'll be down for trial. It's gonna be
Yeah, she's got.
Is this what he told me?
That's a good question.
Well, he's.
I'm technology literate, but I'm trying to figure it out for you.
Okay,
What is it?
Yeah, I think you guys.
Yeah, well, not, maybe not that you just said. Yeah, I got all this stuff in one food.
There it is.
Okay, now, Mr. Harper, I see that you have a DWI second. And I see that there was a Smart Start interlock that was ordered. Is that correct?
Yeah, it's been in my truck for over a year now.
Okay, that's okay. Uh, Okay, I'm gonna give you some bond conditions. Apparently, it's not this stuff. Uh, could you make a copy of these bond conditions? So I could give him a copy?
You just want one?
Yes, for him.
No, he says I'm unreasonable.
Okay, now, Mr. Harper, I'm handing your attorney a document that is titled Standard Bond Conditions in County Court Law Number 2. I'll go over these bond conditions with you. And it's to state, following the return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered, subject to additional conditions. Number one, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
I was reading this, I didn't.
Okay, did you understand number one? Just follow along with me. We'll get to we're gonna go through this whole document,
Okay.
okay? Number one, defendant shall, well, I'm gonna start at the top. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to conditions. Number one, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Okay, condition number two, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 does not apply. However, condition number 4 does apply because your case is a DWI second and it is listed under section 49.04 through 4906 of the Texas Penal Code. And condition number 4 states, a defendant whose information charges any subsequent offense listed under section 4904 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after the date. And it's my understanding that you have the interlock. Is that correct? All right. Now, I think we had in the file, there is a note that says Smart started ignition interlock report, so we can use that to verify that you do have the interlock. All right. Now, condition number 5, defendant shall obtain, maintain, pay for, and have no violations on the ignition interlock device, mobile brake device. Any violation will be grounds for revocation. Do you understand that? And condition number 6, defendant must attend AANA meetings 3 times a week and provide proof to the court. Do you understand that condition?
No, we would object to that condition, that he shouldn't be required to attend any type of rehabilitation, AA or NA, because he's presumed to be innocent. Additionally, to require him to attend NA or NA would impose upon him conditions that were violative of his First Amendment right. As far as the treatment modality of NA and AA requiring acknowledgement of a higher power, which would impose upon him an affirmative obligation to be compelled to engage in the belief system.
Okay,
That's the treatment modality of AA, and that you have to acknowledge that there's a fire. And that's against his First Amendment right.
okay. Well, what we can do is I could require that as a condition of his bond that he attend ATAR. Okay,
Secular.
okay, alcohol treatment and recovery program through Spindletop.
So you should consult with Spindletop, Your Honor.
No, I'm just saying that that'll be a requirement.
So could he be given an option to do that?
Well, that's what I'm saying. If he doesn't want to do AANA meetings, we can do he can go to ATAR.
I would object just in general from this being, would be something like a condition of probation, not a condition.
No, it's not it's a condition of bond.
But he hasn't been determined to be responsible for the offense. He's presumed to be guilty.
I'm-
He's having conditions
I
that are.
I understand that, but one of the requirements of the bond that the court consider is the public safety. And that's why this condition is in there because of public safety.
Would just argue that exceeds the scope allowed in the court to set bond conditions under Article 17 of the Code of Criminal Procedure.
Okay, well, so if he
He will
doesn't want
comply,
to do
Your Honor,
okay, I'm just saying if he doesn't want to do the AANA, then we can require that he does ATAR. So
You have the option.
Yeah, choose one or the other.
Mhm.
Okay,
so which one would you?
I don't know I don't know which one is which, like, how they're gonna go with my work schedule.
Oh,
So
they'll
I can
comply with.
Contact them both and find out.
Well, they'll comply with your work schedule because I mean some of them you even could do online.
I've never heard of the second one.
Okay, it's a program as part of the Spindletop Center. It's called Addiction Treatment and Recovery. It's the acronym is ATAR, ATAR, a treatment, addiction treatment and recovery. That's what it means. Okay. So if you prefer to do the ATAR instead of the AANA, we can do that.
What time is it? When?
Well,
How long is it?
what you'll do is you'll contact them and tell them your schedule. They can set up a schedule with you.
Can I contact both of them?
Well, AANA, you just got.
Yeah, AANA, there's you could pick any one of these places in the county that you can go
I
to.
have to drive to go to the.
Oh, some of them, like I said, some of them you could do online.
I don't know. Just check with please.
Okay. Do I have to pick one of them right now?
No, you can do it.
No, I mean, right now, I mean, these bond concessions gonna be signed today. So if you don't want to do AANA, then we'll just do,
Which one should I do?
Probably the easier.
Okay, that's fine.
so which one, the AANA?
Fine.
Okay, I'm going to give you a list to your attorney. That's a signing sheet. Anytime that you go, a sponsor will sign, and then then you'll bring that form back to court when you come to court to verify that you've been attending. And these are places, I'm giving this list that you can go to any one of those places. You can talk to them, find out which one is best for you. You probably got one near your home. Okay. Okay. So this case is going to be reset. And give us a reset date. Trial, yes.
October 27th.
Okay, this case is going to be reset to October 27, 2025. You're gonna get your reset from our court coordinator. Once you get your reset, you'll be free to go. And you have a blessed day. And oh, he's sitting right. Stand in front of court coordinator. She'll give you a reset and you'll be free to go. You have a blessed day. Damian Leger. It's 2K.
That's it.
Okay, Mr. Leger, you have 2 cases. Cause number 25 CCCR 1306 and cause number 25 CCCR 1307. Both cases are styled the state of Texas versus Damian Leger. Mr. Leger, is that your full name?
Yes, sir.
How are you doing, Mr. Leger? That's good. Now, Mr. Leger, you're represented in your cases by your attorney, Attorney Wright Kimler. And Attorney Kimler, what is your announcement in Mr. Leger's cases?
No,
Trial? Okay. Let me do this here.
Can you read it?
yeah.
Okay, Mr. Leger, your cases will be set for trial. Could you give us a trial date? October 27th. Your cases will be set for trial on October 27th. Mr. Leger?
You said October 27th, Judge?
Yes. Mr.
Hmm? Give me a 20.
You may have copied this. I need to give him some vital conditions.
No, Fred. No. No,
I think other
no,
people
no.
Under my approach.
Mr. Leger, I have a document that I'm going to give to your attorney. And your attorney is going to give you this document. I'm going to go over this document, which is, the document is titled Standard Bond Conditions in County Court at Law number 2. And it states, following return of a permanent remission in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Mhm.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yeah.
And condition number 3 and condition number 4 does not apply. However, condition number 5 does apply. On page 2, it says defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that
Your
condition?
Honor, yeah, we would object to that. That's a violation of the Constitution. Second Amendment, he has a constitutional right to possess a firearm that's not obviated by the fact that he has a misdemeanor offense. Additionally, it violates equal protection by carving out an exception for a member of law enforcement who would be in the same or similar circumstances. Defendant would be allowed to possess a firearm simply because they're a law enforcement officer. That violates equal protection. It's an unconstitutional requirement. He
Okay,
has a right to defend himself, even though it's a misdemeanor. It deprive him of a right to possess a firearm to defend himself because of a pending misdemeanor is ultra virus. The power the court has to set reasonable bond conditions. I would argue.
okay. Okay, so now do you understand that condition?
Mm.
And now again, this condition is predicated on the public safety. And so if you violate any one of these bond conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest.
Your Honor,
All right.
if it's public safety, why wouldn't a law enforcement, somebody in law enforcement is a law enforcement officer who's then alleged to engage in the same conduct, why would they be allowed? It seems like public safety would dictate that a person who's law enforcement, even more than him, should not be able to possess a firearm. I mean, if it's fair to him to deprive him of his right to possess a firearm as he's charged with this offense, the same should apply to somebody that's a law enforcement.
Well, I mean, if you think about it, if law enforcement officers commit a crime, obviously he's going to be suspended,
But he could still possess a
and
firearm.
well, he'll probably be no longer. What is the condition? Hold on.
Well,
Let me see that. Let me see the bond condition.
It's-
Sworn full-time paid employee. If he's suspended, I'm sure he'd be suspended without pay. Yeah. Okay. Okay, so those are the bond conditions. If you violate any one of these bond conditions, your bond will be revoked. And if your bond is revoked, the warrant will be issued for your arrest. Do you understand that?
Okay, yeah, get your back.
Okay. Next case. Oh, I mean, I didn't, before we did that, I didn't get a state of opportunity to, hold on, Mr.
State was just gonna ask for it to be set for a hearing if that's the case, Judge,
You want to be set for a hearing?
if that's the route that Rick wants to go.
So,
They want to set,
You want
set it for a hearing?
yeah, that's an important, that's an important.
Okay.
We can set it for a hearing, Judge.
Okay,
do that.
well, what we're gonna do, we're gonna set it for a hearing?
I'll brief it, I'll brief it.
Okay, that's fine.
Just set it for a hearing.
Yeah, set it for a hearing on, before we get to the trial.
Okay.
Okay, we'll do that.
Get your paperwork.
That's gonna be the trial.
No, let's do it, let's just set it for a hearing first. Hey, give her those paper, give her that paperwork back. We're gonna set it for a hearing. Yes,
Yeah. It's how it's being. And your opinion. Money match.
Edward Leroy Woods.
I'm just gonna sit down.
Yeah, all of these cases, they said.
Thank you.
Hold on, Mr. Woods. Mr. Woods, your full name is Edward Leroy Woods?
The second.
Okay, the second. How you doing, Mr. Woods?
Okay.
That's good. Now, Mr. Woods, you're represented in your case by your attorney, Attorney Wright Kimler, Attorney Kimler. What is your announcement in Mr. Woods' case?
I try.
Yes. Okay, this case will be reset to October 27th of 2025. Now, Mr. Woods, you're gonna get your reset from your attorney. Once you get your reset, not from your attorney, from our court coordinator. Once you get your reset, you'll be free to go, and you have a blessed day.
As far as his bonding conditions, Your Honor, I think there is an assault, so would you want to go over those? I think because there should be a no contact in there.
Oh, hold on a minute. Okay, give me bond conditions, okay. Sorry.
We actually need to just assume. That was. Chances. Eight, 35850 was investigated. And then hopefully they'll just drop it.
Okay, you make a copy of these bond conditions.
More than.
Let me do this while she's making a copy, trying Okay, she's making a copy for you, but in the meantime, I'm going to go over the bond conditions with you. And it states standard bond conditions in County Court Law Number 2 following return of a criminal information in County Court Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws. Go ahead. You make that. Okay, number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. the court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, I do.
Okay, now, let's see, Woods, if you violate any one of these bond conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. Do you understand?
Yeah.
Okay, you're gonna get your reset from our court coordinator. Once you get your reset, you'll be free to go, and you have a blessed day. Right. She wanted to tell you about the hearing.
So,
No, I'm asking you, you're gonna do it like on. With,
Hold on a minute. Let me get this person that songs. I gotta, let me do this here.
No, but what day you wanna do it, Tuesday?
Vu Hong,
Yes, sir.
okay, Mr. Hong. How are you doing?
I'm doing all right, Your Honor.
You doing all right?
Yes, sir.
Mr. Hong, you're represented in your case by your attorney, Brock Anthony White,
Yes, Your Honor.
and
He's on
Mr.
there.
White is on Zoom.
Yes.
Okay, Mr. White, you can take your mic off of mute. Okay, Attorney White, you can take your mic off of mute. Okay. Mr. Hong, we're gonna come back to your case.
Okay.
In a little bit. Hold on. Yeah. Okay, Mr. White, you can take your mic off of mute. Is he? Okay, Mr. White.
Sorry about that, Your Honor. I was in front of a judge. Yes, Your Honor.
Okay. How are you doing, Mr. White? Mr. White, how are you doing?
Your Honor, I'm on mute. I think I'm good, and you, Your Honor. I think the court muted me.
No, you're not on mute. We can hear you.
Can you hear me?
Yes, I was hearing some noise in the background too from your mic. Now, Mr.
Good morning, Your Honor.
Well, good morning. How are you
Okay,
doing?
I'm sorry. Yes, sir. I
I
apologize.
think his
I'm in the
thing
holdover.
is,
So I apologize.
freezing up.
I'll get back in action.
I'm doing
I'm
fine.
good. Good morning, Your Honor.
Thanks
How
for
are you?
asking. Now, Mr. White, what is your announcement in Mr. Hong's case?
Your Honor?
Yes, what's your announcement in Mr. Hong's case?
Yes, Your Honor. So I was explaining to the state, I have not received the video on Mr. Hong yet. So at this time, I have to announce not ready.
Okay.
This case, the BAC came back below the legal limit, but we're trying to allege that he lost his mental or physical faculties on his performance on the SFSTs.
Okay, give us a reset date. We're gonna reset it for an announcement. Okay, this case.
Yes, Your Honor.
This case will be reset to October 22nd, 2025, for announcement. Your reset will be sent to you. Mr. White and Mr. Hong, stay in contact with your attorney and your bondsman. They will be given notice of your reset, and it is set for October 22nd at 9 a.m. Okay, Mr. Hong,
Yes, sir.
you're free to go, and Attorney White, you're also free to go. Both you and Mr. White have a blessed day.
You do, Your Honor. Thank you.
You too, Your Honor. Thank you so much.
You're welcome. Tito Simpson. Mr. Simpson, your full name is Keto Denard Simpson.
Yes, sir.
How are you doing, Mr. Simpson?
Good, and you?
I'm doing fine, thanks for asking. Now, Mr. Simpson. Let's see what we got. Magistrate 20. Hold on a minute. Get the- Daily conduct discharges, pay for. Also, better. This one. Yes. Okay. Mr. Simpson, you're representing your case by your attorney Charles Rojas. Mr. Rojas, how are you doing?
Doing well, Judge, thank you.
That's good. And again, Mr. Simpson, how are you doing?
Doing good.
That's good. Now, Mr. Rojas, what is your announcement in Mr. Simpson's case?
I'd like to go to another announcement docket, Judge, anytime we get the video.
Video. Okay. Give us a reset date. This is on the announcement docket. We only have one case on the MTRP docket.
October 22nd.
October 22nd?
Yes.
Okay, this case will be reset October 22nd, 2025 at 9 a.m. Mr. Simpson, you'll get your reset from our court coordinator. Once you get your reset, you're free to go. You have a blessed day. And
Thank
Mr.
you, sir.
Rojas,
That's all I have, Judge.
yeah, I think we're gonna see you at 10:30.
Yes, sir.
All right. Do we have any?
Three dismissals on MTRP, Your Honor.
Okay. Evan SK. Mr. SK, and your full name is Evan SK?
Yes, sir. Yes,
How
sir.
are you doing, Mr. SK?
Good, how are you doing?
I'm doing fine, thanks for asking. Now, Mr. SK, the probation office is represented in this case by Mr. Gary Gilliam. And Mr. Gilliam, how are you doing?
Very well, thank you, sir.
Okay. And Ms. Simmons, what is the recommendation?
The recommendation is that all three cases or all three MTRPs be dismissed for the to be continued on probation, Your Honor.
Okay,
He has become compliant on all terms.
okay. Now, Mr. SK, the state is recommending that your motion to revoke probations be dismissed. And I'm going to sign the dismissals. You'll be able to get a copy of the dismissals from our court coordinator. Now, your probation has not expired, so that simply means that you're still on probation,
Yes.
okay? So you can get a stand in front of our court coordinator. She'll give you a copy once I sign these motion to dismiss the motion to revoke probation, and then you'll be free to go,
Thank you.
and you have a blessed day. You're welcome.
You want me to approach?
Yeah, hold on a minute.
Just one case.
So may I be dismissed as well?
Yeah, you may be excused.
Thank you, sir.
You're welcome.
Good day. Good luck.
Donnie Lee Hilton. Mr. Hilton, your full name is Donnie Lee Hilton.
Yes, sir.
How are you doing, Mr. Hilton?
All right, you?
I'm doing fine. Thanks for asking. Mr. Hilton, you're represented by your attorney, Attorney James Paget. Mr. Paget, how are you doing?
Doing well. Good morning, Your Honor.
Good morning. Mr. Paget, what is your announcement in Mr. Hilton's case?
Your Honor, we're waiting to complete the video discovery,
Okay. Give us a reset.
and I'll communicate with Ms. Simmons regarding an offer shortly.
Shane's the 80 hours.
Oh, okay.
Okay. So, Mr. Hilton, your case will be reset until October 22nd, 2025 for announcement from your attorney. And, you'll be given a copy of the reset from our court coordinator. Once you get a copy, you're free to go. And you have a blessed day.
You too, sir.
Thank you. And Mr. Paget, you can get a copy of the reset. You'll be free to go as well.
Thank
You
you,
have a
Your
blessed
Honor.
day. You're
Thank you,
welcome.
Ms. Simmons.
Reynolds? Brianna Deshae George?
Before we start, this was a plea bargain. She's supposed to pay a fine. Was supposed to come back today with her money. She has a third-party check,
Oh,
which
what?
means she's not gonna be able to pay the cash right now. I don't know if the court would allow her to wait till,
She have till 5 o'clock PM today to pay.
so you can take her plea now. She'll have to
Yeah.
5 to pay the money.
Yeah,
Okay, all right, we can go. from
yeah, that'll be fine.
I just want to make sure, Glenn, you got that it was 2 days credited towards it.
Yes.
Okay.
Just double checking.
2 days credit toward the fine.
Yes, Your Honor.
Okay. Okay, this is cause number 25 CCCR 0694. Case is style of state of Texas versus Brianna Deshae George. Ms. George, is that your full name? Ms. George, would you please raise your right hand? Ms. George, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. George, you may put your hand down. How are you doing, Ms. George?
Nervous, but I'm okay.
Oh, well, you could just relax. You have your attorney here. He is your mouthpiece. He's gonna he's real competent, and you don't have anything to worry about. Okay? Now, Ms. George, you're represented by your attorney Nathan Reynolds Jr. And Mr. Reynolds, how are you doing?
I'm doing well, Judge, thank you.
That's good. Now, Mr. Reynolds, do you waive a record in Ms. George's case?
So wait,
Okay. Now, Ms. George, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Brianna Deshae George, on or about November 29th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failed to identify fugitive with intent to give false information. Ms. George, do you understand what you have been charged with?
Yes, sir.
To this charge, Ms. George, how do you plead?
Guilty.
Guilty. Now, are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Okay. Now, Ms. George, I also have before me a document that is titled Misdemeanor Plea Admonishment, and this document is on my tablet. Do you recognize this document?
Yes.
Okay, I saw you squint your eyes. And is this your signature, your initials on the line that's titled guilty? On the next page of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper. Oops. That is titled, I got two discovery, sir. They had a blank one behind it. Okay. A document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Ms. George, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
And Ms. George, are you a citizen of the United States?
Yes, sir.
Say that for 6-1.
Any objections?
No objection, states.
No objections. State's Exhibit number 1 will be admitted. And Mr. Reynolds, you have advised and counseled Ms. George. Is there any evidence that she is currently mentally incompetent to stand trial?
None to my knowledge.
Ms. George, your attorney, Mr. Reynolds, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. George, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
State's offering a $200 fine plus court costs and 2 days of Jefferson County jail fee corrected for that. Your Honor.
What's the court cost? Okay, 2 days, right? Miss George, the state is offering that you pay a fine of $200 plus court costs of $277, which comes to a total of $477. You will be given 2 days credit. And when you get credit, it's $100 per day. So we will subtract $200 for the 2-day credit from the $477, and that leaves a balance of $277. Now, would you be able to pay the $277?
Say to me.
$287?
$10.
So the court cost is is $287, excuse me. And so that's 487 minus 200, which leaves a balance of 287. And you'll be able to pay the 287 today?
Yes, sir.
All right. Now, Miss George, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Ms. George, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Ms. George, you're gonna stand next to the bailiff at the end of this table. Follow her directions. Once you follow her directions, you'll be free to go. You have a blessed day. And you're going to, sometime the day before 5 p.m., you'll go downstairs to the county clerk's office, make that payment. You have to bring your paperwork with you. You make that payment, and then they're going to give you a receipt. You need to bring that receipt back up to the court.
Okay.
All right, and if the court will be in trial, if we're not in session, you'll go through the blue doors right here, and the lady sitting behind the glass window, and she can contact one of the court coordinators, and they'll come in and get it from you. All right, you have a blessed day.
You too.
Thank you, Judge.
Okay, you're welcome. Yes. Oh.
You get me the jail one, see? I can hang it up, where is it? She said it really flattered me. Oh.
Okay, the next case is cause number 24 CCCR 1408. Case is styled the state of Texas versus Pandarian Carrier. Mr. Carrier, is that your full name?
Yes, sir.
How are you doing, Mr. Carrier?
Good. I can't complain about you.
That's good. I'm doing fine. Thanks for asking. Let's check. Now, Mr. Carrier, you're represented in your case by your attorney, Attorney Bob Provo. Ms. Provo, how are you doing?
I'm doing fine, but you.
I'm doing fine. Thanks for asking, Ms. Provo. Ms. Provo, what is your announcement in Mr. Carrier's case?
I'm in the process of getting discovery on this case, and I need another, normal reset on this.
Okay, give us a reset date. Okay, this case will be reset to October 22nd, 2025. And Ms. Provo, you get your reset from our court coordinator. Once you get your reset, you'll be free to go. And you have a blessed day. And Mr. Carrier, you also get a reset from our court coordinator. Once you get your reset, you'll be free to go and you have a blessed day.
Yes, sir. Thank you.
All right, you're welcome.
Maybe be excused.
Yes, you may. You may be excused. So we got one left. I see Mr. Boudreaux is working on a plea.
Yes, Your Honor.
Okay, so we'll be in recess. This is cause number 24 CCCR 1044. Case is filed in the state of Texas versus Christopher J. Gilbert. Mr. Gilbert, is that your full name?
Yeah.
Mr. Gilbert, would you please raise your right hand? Mr. Gilbert, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Gilbert, you may put your hand down. How are you doing, Mr. Gilbert? I'm doing fine, thanks for asking. Mr. Gilbert, you're representing your case by your attorney, Attorney Don Boudreaux. Attorney Boudreaux, how are you doing?
Just fine, sir.
That's good. And Mr. Boudreaux, did you waive a record in Mr. Gilbert's case?
Yes, sir.
Mr. Gilbert, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Christopher J. Gilbert, on or about March the 8th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Mr. Gilbert, do you understand what you have been charged with?
Yes, sir.
To this charge, how do you plead? Guilty, not guilty, or no contest? Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means.
Yeah.
Now, Mr. Gilbert, I also have before me a document that is titled Misdemeanor Plea Admonishment. It is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled Discovery Certification. Do you recognize this document? Is this your signature on the line that's titled Defendant? Mr. Gilbert, before you signed and initialed all of these documents that I've just showed you, did your attorney, Mr. Boudreaux, go over these documents with you?
Yes.
Did you understand everything that Mr. Boudreaux went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Mr. Gilbert, are you a citizen of the United States?
State Officer 61.
Any objections?
No, sir.
No objections. State's Exhibit Number 1 will be admitted. Mr. Boudreaux, you have advised and counseled Mr. Gilbert. Is there any evidence that he is currently mentally incompetent to stand
No,
trial?
sir.
And Mr. Gilbert, your attorney, Mr. Boudreaux, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation? Mr. Gilbert, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
State's offering 180 days probated over 1 year with a $500 fine, 40 hours community service and court cost. And the state has agreed to credit 5 days of Jefferson County jail towards that fine and court cost, Your Honor.
So it's 5 days credit?
Yes, Your Honor.
And Mr. Boudreaux, were you appointed in this case?
Yes.
Yes, sir.
And let's see, what's the court cost?
277. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . .
Okay, Mr. Gilbert, the state is offering that you serve 180 days in Jefferson County Jail. However, you will not be required to serve the 180 days in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $277. Now, you will be given, that comes to a total of $777. You'll be given 5 days credit towards your fine and court costs. That means that for every day you'll be given $100 credit. So you'll be credited $500 towards your fine and court costs. So we'll subtract the 500 from the 777 and it leaves 277. All right. You will also be required to pay court costs, not court costs. You'll be required to pay a probation fee in the amount of $60 a month, a urinalysis fee in the amount of $15 a month, and a reimbursement fee of $15. You'll also be required to reimburse Jefferson County Court appointed attorney's fees of $350. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $140 a month. Will you be able to pay the $140 each month?
I got a lot. I've almost owed like $10,000 on other
Okay,
things.
let me see his affidavit of indigence. Okay, Mr. Gilbert, I'm handing a document to your attorney that is titled Jefferson County Affidavit of Indigence. Your attorney is going to hand that document to you for you to review. Would you please review that document? Do you recognize that document? On page 2, there's a signature above the line that's titled Defendant at the top left-hand corner. Is that your signature? All right. Now, is everything in that document still true and correct today? Okay. Mr. Gilbert, the court is going to, let's see. Court is going to find that you're indigent.
Community service to the.
Okay, Mr. Gilbert, the state is offering that you serve 180 days in Jefferson County Jail. However, you're not serving time in Jefferson County Jail because you'll be on probation for a period of 1 year. During the 1 year probationary period, you're required to pay a fine of $500 plus court costs of $277. You'll be given 5 days credit toward the fine and court costs, which means that you have a balance of $277. The $277 court costs will be converted to 22 hours of community service pursuant to Article 42.15 of the Texas Code of Criminal Procedure. The attorney's fees in this case of $350 will be waived pursuant to Article 26.05G-11 of the Texas Code of Criminal Procedure. The reimbursement fee of $15 in this case will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. That means you won't have to pay that either. Now, the probation fee in this case will be reduced to the statutory minimum of $25 a month, and you'll be required to pay the urinalysis fee of $15 a month. The total monthly installments that you'll be required to pay each month is $44 a month. Okay, would you be able to pay the $44 each month? Now, Mr. Gilbert, you'll also be required to perform 40 hours of community service in addition to the 22 that was converted from fine and court costs. And it comes to a total of 62 hours of community service. Do you understand that?
Yes, I do.
You also be required to adhere to the other standard terms and conditions of this probation. And Mr. Gilbert, do you understand the state's offer?
Yes, I do.
And the adjustments that court have made
Yes.
with the finding that you are indigent? And do you think that is fair and just? And do you accept it?
Yes, I do.
Okay, Mr. Gilbert, I'll follow the people who are in agreement with the finding of indigency in this case. And Mr. Gilbert, just have a seat, wait for your name to be called. They have to redo the paperwork to make the necessary changes. And once they make those necessary changes, you'll follow the directions of the bailiff. And once you finish following the directions of the bailiff, you'll be free to go and you have a blessed day. And Mr. Boudreaux, you're free to go as well, and you have a blessed day.
Sorry I'm late, Judge, but I had to go all the way around town,
Oh, that's fine, that's fine, yeah,
just like old days.
all right, I understand that, all right. Now, we need to have, okay, I will. Let the record reflect that the court is back in session in clause number 25 CCCR 0107. Case is style of state of Texas versus Wiltavian Johnson. Let the record reflect Mr. Johnson is present with his attorney. State is present with assistant criminal district attorneys. Let the record also reflect that the jury is now present and seated in the courtroom. And Mr. Kimler, your next witness is,
Yeah, we call Linda Simon.
and Ms. Simon, you have previously been sworn in, is that correct?
Yes.
Okay,
Would
yes, you may proceed.
you identify yourself by stating your full name and spelling your last name?
Linda Simon, spelling is SIMON.
You go by any other names?
Mozzie.
Mozzie, where's that come from?
I've been having it since I was 3 days old.
I'm sorry.
I've been having it since I was like 3 days old.
For some reason, if you don't know. Mozzie.
My mom gave me another baby, so
And what's your date of birth?
January 2nd, 2000.
I'm gonna call you Miss Simon. Miss Simon, you've been in court through part of the trial before the state invoked the rule of sequestration of witnesses, so you were able to hear the testimony of Raquel West. You didn't hear the testimony of the other witness, our other witness, and Mr. Johnson's testimony, but you did hear Ms. West's testimony, right? And you recall that testimony, correct?
Yes.
I'm gonna try to get through this pretty quick, so I'm just gonna ask you heard her testimony, what is your version of what happened?
One, I did not stroke her the way she said I stroked her.
Wait, let me back up to you for a moment. You're also a criminal defendant, is that right?
I am.
And you've been charged for an assault against Ms. West,
Yes, sir.
and so you're here, and you're waiving your right to not testify in your own behalf or otherwise, correct?
Right.
And your attorney, yeah, he's here, Mr. Rojas, right?
Yes, sir.
They all consulted about you testifying,
Correct.
and you've decided on your own, you haven't been subpoenaed or compelled, that you want to testify, is that right?
Yes, sir.
Okay. Now, tell us your version of what happened.
I did not attack Raquel the way she said I did. I did, like, I was getting an altercation with another somebody at the party, which is the sister of the baby mom. When they was attacking.
Sister of another baby mama.
Yeah.
And let's just say mother.
Okay, the sister and the
Mother,
Megan's kid's mother
right, okay.
and the sister. I was fighting them, and there was a lot of them fighting me. So
A lot of confusion.
yes, there was a lot going on. So she did like come up to me. I didn't know what.
Let's be careful when we say he or she, you want to say
Miss
the name.
West, Miss West ran up on me, so I hit her. And it was because there's a lot of people coming up towards me, so I'm thinking everybody's attacking me, so I did.
So you thought you were defending yourself.
Yes, correct. And during that time, Will Tavian was pushing everybody off, like trying to, since I was getting attacked, he was moving everybody out the way. And she was one of the people that he moved out the way.
When you say move, I mean, he wasn't politely, he was shoving, trying to.
Yes, he pushed them out the way,
To describe what he was doing, the best you remember, what was he doing with the other, to try to get him off of you?
pushing them out the way, like literally pushing them out the way.
It wasn't hitting him.
No, he did not have ball his fist up to nobody.
Did you ever see him hit Raquel West in the back of the head and knock her
No,
to the
sir.
ground?
I never saw him here.
Do you think that he did that?
No, sir, it did not happen.
Didn't happen. So your opinion, she's lying.
Yes, sir. I'm telling you, she was telling us with it.
Really, we got the exhibits. All right. But you've had seen these, basically with one, right, she appears to have an injury to her head. right? You know how that happens or not?
Did that.
Well, you did that.
I did do that.
So you did that with a bunch of her?
Yes, when she ran up, I popped her in the face, like literally.
Were you sure that you did that, or did she do that when she fell and hit the person?
I don't know. See, I've never seen this picture before until today. So
Hey, look at it, look, before you say that, look really careful. Alright,
when she ran up on me, I popped her.
okay,
That's all I'm gonna say. I don't know if that is particular not is from me, but I did pop her in her face.
whereabouts in her face?
I just like, it was like so much going on. I just hit her. Like I just,
Well, you're not some sort of trained officer or officer, you know, right? No training in boxing.
no, sir.
And you don't know where you hit her?
I'm telling you, it was in her face. Like, I'm not sure if it was like up here, but it
Just,
was,
just to cover you in your next trial, were you in immediate fear of your safety when you did that?
yes, I was like, told me, like the whole family was coming towards me and I'm not sure if anybody trying to protect it, cause before it even got to that point, nobody was trying to stop it. The only person that was just trying to stop it was Will Savior. Literally, like he was the only one.
So you don't know that you did that.
I don't know if I did that, but I did.
Did you ever see her fall to the pavement?
She did. I hit her and she fell, and then I know when Will was pushing her, she fell, so.
So that was two different times, she got up and hit the
Yeah.
pavement again? Okay.
It was an aggressive situation, so,
Were you injured?
yes, it was a lot, like, it was a lot going on.
Were you injured?
I did get injured, I also pressed charges too, but I don't know what happened to.
Well, and I was gonna ask you about that too, because did you ever talk to the police about
Yeah, they
this?
took a picture of my face and everything. I got injured also as well. I don't know what happened to the charges because the kids, so we rented out like jump the table and stuff like that. That also got stolen that night. So I had to press charges to protect myself because the place that we rented from was trying to charge me $1,500 for the stuff that got stolen.
Maybe you just shouldn't have birthday parties anymore. I mean,
Oh yeah, that's stolen with.
so do you remember the officer that you talked to?
I don't know the officer whom I talked to, but I do remember sending my statement in and I had like the little card with the reference number. Yeah, so after we got in trouble in January when we got like out of jail for this, yes, when I got out, I had called and I was like, I had pressed charges, why did my charges didn't go through?
Who did you
Yes.
press charges on?
I was, people that jumped me.
What name? Who was his name?
Ashley Wilson. It was Alexis Tucson, Raquel West, Marie Jackson, and also Bonnie, I don't know her last name.
It's about 5 people.
So it's about 5 people.
And you had visible injury.
And I had visual.
What were your injuries? What did they look?
Okay, so in part of the altercation, I had ended up falling and like I got pulled down to the ground and I had like a black eye.
Okay.
So,
So you had an injury to your eye,
yes, that was the only thing that I had.
but it was visible. You could see it, right? Did the officer take a picture of
Yes,
it?
he took a picture.
To your knowledge, were charges ever filed against the
No,
person?
I called it, like, we don't have no record of it, and then I was like, well, I sent it in, cause the party happened on Saturday. I had, went to work that Monday, and that's when I like filed it, because I was at work and I had this eye problem, so I had it at my job, and they took a picture and everything.
Okay. Well, just to be clear, Will Tavian, to your knowledge, recollection, did not hit
No, sir, he did not hit it.
Ms. West.
Mhm.
And whatever you did in self-defense because you were in
Yes.
fear.
He was protecting me and I was protecting myself.
Pastor,
Okay. Mr. Huber?
Thank you. So to be clear, and good morning, Ms. Hoffman, how are you? How are
I'm
you?
okay.
To be clear, you were a defendant from the same criminal episode, correct?
Correct.
And you admit to striking Miss West, is that correct?
Yes, sir.
And earlier, I believe your testimony was that you were being the family members were coming up on you, so you didn't know it happened so fast, whether or not Miss West was actually being aggressive towards you. That time.
Correct.
And so it is also your testimony that Will was pushing people over, right?
Yes,
And that he pushed Raquel over. Yes. So initially you struck her and she fell to the ground one time. Is that correct? And then Will, by your testimony, shoved her and then she fell a second time.
yes, he was pushing me back away.
So y'all were involved in a fight, which you initiated by striking Miss West in the face.
Miss West was not the initial person that I was altercation. with.
Right, but you struck her and she had
Yes,
not
but she
done
ran-
anything.
Yes, sir.
She had not done anything aggressive towards you.
But she was coming towards me, so you coming towards me and I got 50 other people coming towards me. I was swinging, so she was one of the people I hit.
But you were not personally aware of her intent.
And I was not real her intentions.
Okay, and so you strike her first. She has not struck you, or she's only approached you. She is not. She doesn't have her fist balls or anything at this point, to your recollection.
Honestly, I don't know if this was bought or not, but the way she was coming at me, I don't think she was trying to stop nothing.
But then, so you strike her first. She falls to the ground, and then she gets back up. And then is it almost instantaneously that Will pushes her back down, or?
No, cause she was like trying to continue, and actually somebody, when I hit her, somebody came and picked her up, and I'm thinking she'd like just get out the way or something, but she came back.
So you struck Raquel, she fell, and then Will struck Raquel and she fell.
Yes.
All right, no further questions.
No further service, Your Honor. What do you got? We'll rest this time.
Okay, and may this witness to be excused?
Yes, Your Honor, she's still subject to the rule.
And Ms. Simon, on yesterday, the court informed you that the rule was invoked and you're gonna be ordered to leave the courtroom, and when you're ordered to leave the courtroom, you're not allowed to come back in unless I give you instructions or the bailiff give you instructions. And you're not to talk to any other witnesses or anyone else except the attorneys. You're not to read any reports or any comments about this case. And as I mentioned to you on yesterday, if you violate this rule, you can be held in contempt of court. Do you understand?
Yes, sir.
Okay, so you're excused and you have a blessed day.
Yes, sir, you too.
Okay, so the defense rest state, you have any rebuttal?
Rebuttal in the state, Your Honor.
Okay. Okay, ladies and gentlemen, of the jury, the state rested, the defense rested, there is no rebuttal. Let's do this here.
Great argument.
Okay, just hold on a minute. We're gonna ask that you step outside for this is gonna be a short period of time, and then we're gonna ask you to come back and we have to have what is called a charge conference. Okay, so please stand and follow the bailiff to the hall. At this time, ladies and gentlemen, the court is going to read to you the court's charge. Members of the jury, the defendant, Wiltavian Johnson, stands charged by information with the offense of assault causing bodily injury, alleged to have been committed in Jefferson County, Texas, on or about the 26th day of October 2024. To this charge, the defendant has entered a plea of not guilty. I now give you the law that applies to this case. Our law provides that a person commits the offense of assault causing bodily injury if the person intentionally, knowingly, or recklessly causes bodily injury to another. So that you may better understand the nature of the offense with which the defendant is charged, I now define certain terms and words. The term bodily injury means physical pain, illness, or any impairment of physical condition. A person acts intentionally or with intent with respect to a result of their conduct when it is their conscious objectives or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of their conduct when they are aware that the conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of their conduct when they are aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Wiltavian Johnson, did in Jefferson County, Texas, on or about the 26th day of October 2024, did then and there intentionally, knowingly, or recklessly cause bodily injury to another, namely Raquel West, hereafter styled the complainant by striking her on the back of the head and knocking her to the ground, you will find the defendant guilty, unless you so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of the offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine the facts or what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced in the evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror or consider it yourself in arriving at a verdict. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page of the charge is the verdict form. It is divided into two parts. The top part states, "We, the jury, find the defendant not guilty as charged in the information of assault causing bodily injury." If that is your charge, then your foreperson will sign on the top line. Or at the bottom it states, "We, the jury, find the defendant guilty as charged in the information of assault causing bodily injury." And if that is your verdict, your foreperson will sign on the bottom line. Does everyone understand? Okay. Now, at this time, we will have closing arguments. State, are you ready? Defense, are you ready?
Ready?
Okay, Mr. Hughes.
State wages break out, there's everything to close.
Okay. And Mr. Kimler, you may proceed.
Oh, we have one.
How much time do you need?
Don't answer that. I mean,
Well, is 30 minutes enough?
I could go ask the thing, we fucking home. Where we have a marker. Might as well.
Hold on a minute. Should. That's the yellow one. You probably need, hold on a minute.
Sorry.
Purple and
I just thought of
green.
something.
Got purple and green.
Don't worry, I'm not gonna be. Ladies and gentlemen, this has been a relatively brief trial, but doesn't mean it's not important. Obviously, any kind of criminal case, it can result in a conviction is important for a misdemeanor court versus felony. I always like to start my arguments with the jury of the observation that the court gives you an instruction to hear this, your duty to see the justice is done. That last thing you tell you, returning the verdict, it's your responsibility to make certain that justice is done in the case. I would simply suggest to you that that is an individual responsibility that each of you have, not a collective duty. What I mean by that is, if you go back into the jury room as an individual drawer and you discuss the case in good faith and you vote your honest opinion, guilt or not guilt, based on your conscience, your common sense, you've done your job. That's seeing that justice is done. It's not some sort of collective duty to return a verdict one way or the other, such that if you go back and you can't agree, and it's what we call a hung jury, you can't come to unanimous agreement. That's not a failure on the part of the jury to see that justice is done. You don't have the duty imposed on you to come back with a verdict. If you can't agree, then just send them with the bailiff, and we can't agree, and the judge will probably just disperse you, and we'll have another trial with another jury to see if they can agree. The only way really that you don't fulfill that obligation to see that justice is done, I would suggest to you, is that you surrender your honest opinion, your honest vote about this case just to come to a vote. I don't know, sometimes people may be pressured into changing their vote just to return, and that's really where you get into, I think, a violent obligation to see that justice is done. It's an individual responsibility. The case turns here on a relatively, we can narrow it down to a relatively simple matter. The state has alleged that Mr. Johnson committed the offense of assault, bodily injury, but they've made an allegation of what's called manner and means of doing it. And they're held with that burden. They have to prove manner and means beyond a reasonable doubt. And particularly, you'll see this in the jury form, the actual verdict form, or the charge here, paragraph 3, right here, right at the end, the general instructions above the judge's signature, where it says, therefore, you believe on the evidence beyond a reasonable doubt that the defendant, Jefferson County, how about today, that didn't intentionally, knowing, or recklessly caused bodily injury to another by Kill West. And then here, by striking her on the back of the head and knocking her to the ground. So you have to believe manner and means beyond reason before you get it. Not just that he caused bodily injury, it's the manner and means. You have to believe beyond a reasonable doubt that he struck her on the back of her head and knocked her to the ground. So that's really the gist of this case, the point of contention between the defense and the state. Whether Mr. Johnson struck Raquel West in the back of the head. And you've heard testimony from Ms. West that he did. You've heard testimony from 3 of the defense witnesses, including the defendant, that he did. So again, as I told you briefly in my opening to you before we put on evidence, because the defense puts on evidence, it doesn't shift the burden to who you believe more. The defense evidence simply sort of contextualizes whether you believe Ms. West's testimony or not. It just gives you further evidence whether you want to believe or beyond it. That's witness. Way it called it, probably before we get there, so it's not the situation. So the defense testimony simply gives you further evidence to contextualize what this was. Get you in mind the standard for the ground. Now, the bulk of this argument, and we'll try to move pretty fast, is the idea of proof beyond reason, the standard of proof in Justice State's case. And it's across the board, that's the standard of the new criminal case, the speeding ticket, proof beyond reason, doesn't change across cases. But the discussion board, there's no definition of proof beyond a reasonable doubt. There is what I call the via negativo. Don't tell you what it's not. It's not proof beyond all possible doubt, not certainty, but it's something less than that. And it's belief, right? And with belief is kind of an odd thing, right? Something that you wrestle with, belief versus knowledge. We're not talking about knowledge. I mean, when you drove to court today, and I'm sure each of you probably went through the traffic control device, the red light. And when that light turned green, you proceeded through the intersection with the idea that you're not gonna be involved in a collision. Now, was that decision based on belief beyond a reasonable doubt that you would have a collision? Was it belief, or was it knowledge? Did you look around, you check, the other cars coming? I know it's the green light, but people run red lights, so I wanna make sure I'm not just going along the light. All right, I'm gonna proceed to the intersection with knowledge. Or did you proceed to the intersection with belief? But belief beyond a reasonable doubt, the intersection, but submit to you that situation, it has what's called epistemic validity. You know, through knowledge, epistemically, that through your own observation, to form an inference that you can go through the intersection. There's no knowledge, not belief. So that really is not belief. Not belief. It's not. That's not what we're talking about here. It's not that kind of certainty. Based on observable facts, it's not knowledge. Well, okay, what about something else, some other decision that may have involved belief, you probably believe beyond a reason? Marriage, right? You get married. You believe beyond a reasonable doubt when you get married that that's gonna be the person that you're gonna spend the rest of your life. You have kids with, that needs to be fine. I believe that beyond a reasonable doubt. Is it based on knowledge? Well, maybe, but it's also belief, because it's the future. I'm not talking about the moment, we're looking at the future. Maybe there's a nagging doubt in the back of your head when you form that conclusion, I believe. But you still act on it. How many of us have been wrong with it? You have that belief beyond a reasonable doubt, you act on it, and it's wrong. So it lacks what you might call a distinguishable beyond that, right? So what we're dealing with here is not knowledge, but is according to the instruction. It's kind of this amorphous idea of belief. Just like saying, kind of touched on religion, belief, God, religion is believing there is no God, the same as lack of belief in it. It's two different things, right? One involves a belief, an act of belief, you believe there is no God, versus a lack of belief, right? Two different things. One still involves a belief system and all the vagaries that are associated with that, even if you believe there is not still a belief system. And I'll show you why I got the marker. The problem with belief is that, right, inside of every belief, right? What do you have? Whatever. Yeah, you got a lie is inside of every belief system. We could be like the Terrence, right? The classical Greek Terrence, Diogenes and Sextus Empiricus. You have the ataraxia, the suspension of all belief and just to achieve a state of mental equilibrium because you don't believe in anything. Ataraxia. We wouldn't have a conclusion in space, but that's my point is simply that belief is a vague and amorphous idea concept conceptually, but it's what we apply in interpretation when we talk about the decision of people's lives. I would suggest to you that really belief beyond a reasonable doubt, even as it's delineating to you in these instructions, I don't know that it's that helpful. And I don't say, trying to give you an idea of what it means. I can't do that. I don't know. All I can say is what's helpful is to try to reify it as much as you can, this idea of belief. And you do that by asking yourselves epistemically, what are the consequences of finding some, right? And that's that they could be punished in this case by being put in jail for up to a year. And how comfortable are you? How assured are you that you're making the right decision when that's the consequence of the decision? Right, that's the standard. Are you gonna doubt yourself by making this decision and potentially subjecting someone to being detained for up to a year in that place on Highway 69, out by that huge hydrogen plant that they're building, where people are detained, where the miscreants and flotsam and jetsam of this county are kept for up to a year without their freedom. How sure do you want to be? How certain do you want to be of that? I'll leave that to you. I would simply suggest that I think that there is reasonable doubt in this case, what I did. And I ask that you return the verdict guilty. Yeah. One other thing, I guess, always one last thing, right? If, I would say this too, okay, is anything I've done, to irritate you or, you know, cause you some sort of discomfort, I apologize for that. Hold that against me and not my client. It's not his fault. And you might ask, well, what, the guy's a lunatic, how's the state bar Texas do all this? Just hold that against me and not my client. Again, I ask that you return the verdict.
Okay, Mr. Hill.
Thank you. Morning, everybody. Thank you all for your patience and attention this week. Like Mr. Kimmer said, this is an important case. It's a misdemeanor, but it's still a case that requires your attention, and you have been providing it this week. So again, thank you. What the defense has talked about in his closing, he talked a lot about philosophy, a lot about love, and a lot about lies. But what he didn't talk about was the elements, and that's what's required for myself, the state, to prove in this case. And those elements that we discussed in Ward they're not, many of them are not conjunction. Like that the offense occurred in Jefferson County. There's no disagreement that it occurred at 1430 Gill Street in Gulf, Texas, but it is in Jefferson County. That it occurred on October 26th of 2024. That's the day of the birthday party. Everyone's testimony reflects that. The defendant, Wiltavian Johnson, was identified by the complaining witness, and he himself testified and gave his name on the record. And as far as the intent element, intentionally, knowingly, or recklessly, I believe that we discussed this during Ward and specifically with Journal 1, Mr. Allred, that intent can be inferred by one's actions. And in fact, the specific example that we used was someone being shoved. And the intent of the person shoving that person, they had to intend or at least know that that person could be injured or fall from that push or that. And then lastly, causing bodily injury to Raquel West. Ms. West's testimony herself, the statement that she was struck on the back of the head, that caused her pain, and that her fall to the ground from that strike also caused her pain to her head and her right elbow. And this is reflected in both the complainant witness's testimony and in Ms. Simon's testimony, with, in which she states that Wiltavian also struck Ms. West, and she caused it. And specifically, Ms. West states that it's the back of the head that she was struck. So whether you're using a ball with a fist or simply or shoving someone to the ground, if you hit someone with enough force that they fall to the ground, that is a strike. And you also have the injury pictures that are within states exhibit 135 to consider in regards to bodily injury. So next I'm going to talk about the testimony from defense's witnesses. And first, talking about the state's witness, Raquel, she gave a consistent, incoherent chain of events as to what happened and how she was assaulted. But then, as I was talking about with Mr. Johnson during his testimony yesterday, the witnesses that he brought were himself, his family, and the other individual was accused of misconduct. So, starting with Lynn, she was very clearly biased against Raquel in her testimony. She does not consider her family. She blames the class of the family's unity on her in this one event. And her testimony is that Miss West was simply drunk at the party and drunkenly fell into herself. Why would someone just drunkenly falling over cause a rift in a close family? The answer to that is that actually wasn't what occurred on that day, and that Miss West was struck by Wiltavian Johnson, causing that divide. Her story does line up with Miss West in that, and everyone's testimony lined up with Miss West, that there was a early disturbance between Wiltavian, Linda, and another one of Wiltavian's the mother of Latavia's children. And, but from that point, it diverges. She says that, that Marie slipped and fell, Marie Jackson, which is someone that we really only hear about through Vince's testimony, witness's testimony, and that Raquel had charged Latavian, swinging at him rapidly and then drunkenly fell. That doesn't line up with, what either Mr. Johnson or, Linda Simon testified to. Because, in both of their testimony, both Latavian and Linda's testimony, West was, going towards Linda, not Latavian. West was not talking about Latavian at all, in either of their testimony. And then Latavian and Linda's testimony differs in that, Raquel was trying to get to Linda and trying to get around him, and, he did not allow her to. But, Linda's testimony was that she did make it, Miss West did make it to Linda, and then Miss Simon struck her first. So the common through lines through all this testimony, though, are what lines up with Miss Raquel West's testimony. The initial argument that happened, the fact that someone did see a gun there. Latavian testified that she had heard that, that he had heard that someone had seen a gun there, and the fact that the individual who was alleged to have had the gun ended up in the car. Like those reflected in both Latavian and Raquel's testimony. So all of these things line up with the complaining witness's testimony, and all the contradictions come from the different perspectives of the defense witnesses. And getting to the point of the assault itself, Linda's testimony, as far as defense witnesses, was most revealing, and that Linda testified that Raquel approached her. She struck Raquel first. Raquel fell to the ground, and then Raquel got back up, and then Latavian shoved Raquel back to the ground, struck her with enough force to knock her to the ground. And this lines up exactly with Raquel's testimony, because Raquel's testimony was that she had first gotten a fight with Linda, which Linda had started, and then that was over, and then Latavian then struck her, and she ended up on the ground. That perfectly matches Raquel's testimony. Raquel's testimony is the one that's the most consistent and coherent, and lines up with the stories that the defense is trying to craft. So, in summary, just review. I would ask that you review the recall the testimony in this case and review these state's exhibits, because the state has met its burden by providing evidence to reach the burden beyond a reasonable doubt for all these elements in this case. The defendant's witnesses contradict each other, and where they don't, they all agree with Raquel. So again, I'm going to thank you for your time. Consider the inconsistencies in the defense's testimony and the consistency with the state's complaining witness. Review the charge and return a true verdict of guilty in this case. Thank you.
Okay, thank you. Okay, ladies and gentlemen of the jury, the evidence, the court's charge, and the closing arguments of counsel are before you. I'm going to hand this charge to a bailiff along with the verdict form. They will be left with you in the jury room. And once all members of the jury are present and assembled in the jury room, the case is formally submitted to you and you may begin your deliberation. Now, before I hand the verdict form to the bailiff, I need to advise you that in a criminal misdemeanor case, we have 6 jurors. And if you notice, you have 7. So one person is what we call the alternate. Now, the alternate will not be allowed to go into the jury room to deliberate with the rest of the jurors unless something happens to one of the jurors, and then the alternate will be allowed to go into the jury room. Okay? Now, the alternate in this case is Mr. Andre Sweeziak Maddox. Okay, Mr. Maddox, you will not be allowed to go into the jury room. Now, you can have a seat in the courtroom if you desire, or you can sit in the hallway near the courtroom unless something happens to one of the jurors, and then you'll be allowed to go in and deliberate. Do you understand? Okay. Now, hold on a minute. Okay. Hey, ladies and gentlemen, of the jury, would you please follow the bailiff into the jury room? Miss Bailiff, here's the charge and the verdict form.
Thank you.
And the court will be in recess till we get a verdict.
Outside.
Okay. Court will be in recess. Let the record, the court is back in session in clause number 25 CCCR 0107. Let the record reflect that the attorney for the state, the attorney for the defendant are present in the courtroom. I have received a message from the jury that it has reached a verdict. Will a bailiff please bring the jury into the courtroom?
Yes.
Will he be able to stand?
Sir,
Will he be able to stand?
probably, you stand, well, you can, yes, we can.
Okay.
Just yourself.
They hold that. Okay. Let the record reflect that the attorney for the state, the attorney for the defendant, and all members of the jury are present in the courtroom. Foreperson. Have you reached a verdict in this case? Is the verdict unanimous? That is one that is agreed upon by all the jurors? Okay, please hand the verdict to the bailiff, Miss. Is that the whole charge?
It's right there.
Okay,
It's two.
yeah, I get that.
Go ahead.
Okay. Yeah, Mr. Johnson, would you please try to stand? Now, foreperson, is the verdict a unanimous verdict agreed upon by all members of the jury?
Yes. Yes.
Okay. We, the jury, find the defendant not guilty as charged in the information of assault causing bodily injury. Does anyone like to have the jury poll?
No, Your Honor.
Okay. Yeah, letters. Ladies and gentlemen of the jury, on behalf of the citizens of Jefferson County and the staff here in County Court at Law Number 2, I'd like to thank you for your time and attention that you have given to this case. I know that you paid close attention to all of the evidence that was presented. You also listened tentatively to all the arguments. And again, you did the job that you were supposed to do. And as I mentioned to you in the charge, in returning your verdict, it was your responsibility to make certain that justice was done in this case. Justice was done in this case. And we'd like to thank you for taking time out from your busy schedules to be here these last 3 days. I mentioned to the members of the panel that anytime that they're in the area of County Court at Law Number 2, and that includes you, that you can come and have a seat in your courtroom. And I mentioned to you that it's your courtroom because this is a courtroom for the citizens of Jefferson County. And as a citizen of Jefferson County, this is your courtroom. I know that you saw my name over the door. It says County Court at Law Number 2, Judge Terrence L. Holmes. And somebody probably said, oh, this is Judge Holmes' court. Well, this is not my court. This is your court. And so anytime that you're in the area, you can come have a seat in that area that we call the peanut gallery. And as I mentioned earlier, you can't bring peanuts in here and eat because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and just see what goes on in Jefferson County. And I know that you'll find it very interesting from the types of cases that we have in this court and the types of cases that we have in this county. Our bailiff, she has some letters for you. She's going to give each and every one of you a letter. And before she gives a letter, I usually give each and every one a handshake. And so I like to give what is called an air handshake. I know we still have COVID in our communities. So again, I like to give each and every one of you an air handshake. And yes, she's going to pass out letters to you. Now, the lawyers in this case may want to talk to some of you or all of you. You do not have to talk to any one of the lawyers if you do not want to. That's your choice. And so at this time, your jury service is complete. Again, I'd like to thank you for being here the last 3 days, and make sure that you return our badges because we use those badges over and over. So I'd like to thank each and every one of you for being here this afternoon. Now, I know that the alternate juror figured that, oh, I just came down here, wasting my time. You did not waste your time because your presence was very important as well. Now, before you leave, I'd like to tell each and every one of you to have a blessed day. And you are excused. Now, if you need anything from our district clerk's office is right across the hall. Okay? You're excused. You have a blessed day. You got it. Who? Who? If he wants one, right, you need a copy of the judgment?
Here you go.
Okay. Okay, here you go. And this will conclude the calling of the court's docket. And the trial in cause number 25 CCCR 0107. Prosecutors and defense attorneys, you're excused. Okay. Everyone, please have a blessed day.